Good morning, everyone, and thank you for joining us at this year's litigation update. My name is Callies, and I am one of the RPFSS board members. Before I introduce our moderator and speakers, I do have a couple of announcements because this is being broadcast for CLE. The program, as you know, is being broadcast to viewers, so please silence your phones and keep the noise down in the room to allow the webcasters to hear the speakers appropriately. To those who are viewing the presentation via webcast, if your video is in full screen mode, please exit it, as you will need to acknowledge checkpoints throughout, and full screen mode will prevent you from seeing those checkpoints. The speakers will be taking questions as they go. So if you do have questions, please raise your hand. Make sure to speak loudly and clearly so that our webcasters can hear you. For those viewing via webcast, there should be a box for Q&A tab where you can type your questions. And HSBA will be monitoring those questions and will provide the presenters with those questions at the appropriate time. For those who have registered for CLE, make sure you check in and out at the front table. It's 1.5 credits. And the webcasters will actually need to submit their own credits at the end of the program. So now I will introduce our panel. The panel will be moderated by Professor David Callies and will feature presentations by Greg Kugle and Mark Murakami. Professor Callies is the Benjamin A. Kudo Professor of Law at the University of Hawaii, where he has taught many of Hawaii's lawyers, including myself, with respect to land use, real property, and state and local government law. Professor Callies has authored or co-authored over 20 books and dozens of articles relating to real property law, takings, and land use and development. In 2015, he was honored by the Owners Council of America, a nationwide network of eminent domain attorneys, for his lifetime of scholarship focusing on takings law and private property rights. Greg Kugle and Mark Murakami are both directors at the Damon law firm and have been gracious enough to provide us with this annual litigation update for at least the past 10, maybe 50?
6? I don't know.
No?
It's been a while.
It's been a while since I've been coming to them. Greg focuses his practice in the area of litigation and appeals for primarily cases involving commercial, business, and construction disputes and land use and real estate litigation. He has consistently been recognized as one of Hawaii's best lawyers in the area of land use and zoning litigation, earning Lawyer of the Year in this category in both 2013 and 17. I should also note that he was the past chair of this section. Mark is also a litigator whose practice is primarily focused on complex commercial disputes and land use, environmental, and general civil litigation. Mark is a graduate of the U.S. Coast Guard Academy and served on active duty for 13 years before joining the reserves in 2005. Like Greg, Mark is also consistently recognized as one of Hawaii's best lawyers, earning the designation of Lawyer of the Year in 2013 for eminent domain and condemnation law. He is the author of a legal blog, which can be found at hawaiioceanlog.com. Make sure to check it out. With that, I'll turn it over to our moderator, Professor Callies. Thank you.
Thank you, Pakoa. My job is very easy here because, as Mark Twain once said, they know all there is to be known about the subject, and I know the rest. So if you have any questions, address it to them. You're here to hear them, not me, and I really have very little to do. As I understand it, we're going to start off with the U.S. Supreme Court's NIC case, which is probably the most important land and policy case that the court has decided in at least 20-25 years, and particularly in Hawaii, where thanks to decisions like the Leone case, where total taking and the rules under the Lucas case that govern it were totally ignored, NIC opens the federal court doors for the first time in about 20 years to litigation by private parties claiming a taking. So those of you that are here representing government, corporate counsel, and so forth, be prepared for a flood of challenges in the federal courts, because I think that's what's going to happen. Without more, turn it over to Mark, I think, who's leading off on NIC.
Yeah, thanks, and we're always glad to come back. I always introduce our comments with the utter surprise that Greg and I always have when the section asks us back to teach, because we tend to think these can be a little dry because we're reviewing fascinating topics like administrative law, Chapter 91, land use. But then this year they asked us to do 90 minutes instead of 60, and then they brought our professor to come moderate us. So either they're trying to keep us honest because they don't believe the Greg and Mark show after all these years, or something else. But anyway, we are glad to be here, and we're going to call a little audible. There were a couple national cases that didn't make it into our handout, and so we'll talk about them briefly. But I think the most important case that's come down this year in the terms of real estate, land use, and property law is the NIC versus Township of Scott case, which arose from the Commonwealth of Pennsylvania and related to a grandmother type person who happened to own a cemetery in her backyard, and there was an ordinance that the township had, like others in Pennsylvania, that required landowners to recognize private easements to access those burial locations. And Miss Nick filed a federal court lawsuit challenging that land use ordinance, and it was with the express, targeted, fully disclosed in the first paragraph of the complaint, attack on the U.S. Supreme Court's decision in Williamson County versus Hamilton Bank, which everybody in the world calls Williamson County except for Professor Callies, who likes to call it the Hamilton Bank case. But anyway, ooh, sore point. Anyway, but for those who went to school before 1985, the U.S. Supreme Court, in a rather bizarre decision that's been largely resoundingly criticized by all fronts of litigants, basically shut the federal court doors to land use and regulatory taking challenges in federal court. And it had two different rationales or core aspects of holding. One is that the land use and the real estate entitlement process has multiple different layers of administrative appeals, remedies that can be provided by the agency, Board of Variance and Appeals, circuit courts under Administrative Procedures Act, as well as getting into the court system under Chapter 91 thereafter, and every state has that same type of relief. And so there was one aspect of the Williamson County decision which said, look, we don't want, federal courts don't want to review these cases too early on, they're not ripe. The second, and perhaps more troubling, and I think the state appellate courts have similar rules, and what's that case, is it Gatry? Leone 1 actually talked about how you don't have to seek general plan amendment in order to bring a land use challenge in state court. Anyway, the second and more vexing component of the Williamson County decision was that in order to successfully bring a regulatory taking or inverse condemnation claim in federal court, you had to have been denied compensation in state court first. And so, the Fifth Amendment, as applied to the states of the 14th Amendment, requires that the government has the power to take property, provided they provide just compensation. And those are kind of the two, for public use, two components to a direct taking. And so the Supreme Court in Williamson County said that before you can file a federal regulatory taking claim in federal court, you had to go be deprived just compensation in state court. Now, okay, you're deprived of federal forum, but so long as you can bring eventually your federal claim after you go to state court first with your state just compensation inverse condemnation claim, perhaps that's okay. Unfortunately, that's not how it turned out in a case in, was it 2005? It was in the mid-2000s in Sanremo versus City of San Francisco. What happened was the practitioners since Williamson County would separate out their claims, and so they would bring the state court claim and the federal court claim separately, expressly reserving it so there was no preclusive effect between, if you bring a state court condemnation, inverse condemnation claim and lose, you don't want to have that be precluded in federal court thereafter. Sanremo actually said, no, you can't separate those out anymore, and the denial of just compensation or your regulatory taking claim in state court will have preclusive effect in federal court. So therefore, wham. The second, and perhaps the more intellectually troubling, or it's hard to kind of capture why the Supreme Court went this way, was the case, and I'm going to get the case site wrong, but if you look up Chicago surgeons or Chicago orthopedic surgeons, it's a Supreme Court case from the same time frame where a state court lawsuit was filed by landowner versus government, asserting the full panoply violations of Fifth Amendment, 14th Amendment, 1983. The municipal government removed the case because there's federal claims, and the removal statute says that if there are federal claims and federal question jurisdiction, you can remove it. And so that went up to the U.S. Supreme Court, and the landowner said, hey, look, I couldn't bring these direct claims in state court. Williamson County says I have to bring it in federal court. Williamson County says I have to bring this claim in state court. How is it possible that when I brought my state court claim, the case can be removed to federal court, and then the government can file a summary judgment or motion to dismiss because of the ripeness problem that they haven't exhausted their remedy in state court yet? And the Supreme Court blessed that in the Chicago surgeons case. Anyway, so it's really kind of unfair scenario if for people trying to bring these claims and without really a good intellectual or rationality to why the Supreme Court did that in Williamson County, because there's tons of claims that involve governmental actions on a daily basis that you can bring in federal court. If I want to protest, fill in the blank, the van cams or the tickets that the cops want to give you if you stop, you go to the crosswalk when the red light starts flashing, you can't do that anymore, it's a $350 ticket. If I want to challenge that, some kind of free association challenge, I can go to federal court for that. But yet the Fifth Amendment and the property rights have had this door shut in their face since 1985. And so really problematic. It's been widely complained about. There were several opportunities the Supreme Court had, including Sanremo, to reverse Williamson County. Ultimately, they did. And in this case, it's a pretty straightforward decision. It was 5-4 with the conservative justices led by, in an opinion authored by Chief Justice Roberts, finding that no, the federal court doors should be opened up. Williamson County was wrong, and these types of claims can be brought and vindicated in federal court without having to do the dance of going to state court first. The 4 liberal progressive justices dissented, and there is a level of what would a decision in favor of Mrs. Nick mean for the federal judiciary with clogged dockets, judicial vacancies. It would open up a whole class of claims that have not been heard in federal court for 25 years. And so are they going to, are we going to have subdivision denial permit appeals going to federal court instead of the BVA or CBA where they probably should belong? Anyway, all those issues I don't think are going to bear themselves out. The exhaustion ripeness requirements still exist. And so I think that the core fundamental bullet point that Nick brings is that federal court, like what Professor Callies said, federal court is now open to these types of challenges and can be brought. And Greg has maybe brought a couple.
I just wanted to throw one thing out, which is kind of interesting, which shows you really to some extent how unfair Williamson County is. The Williamson County didn't know that. I've
convinced them.
Right. What did they say? The justice who wrote that opinion was the justice was one of the so-called Minnesota Twins, and when he wrote the opinion, the first draft that was circulated, when he passed, his papers were available for review first among all the justices that have yet passed recently, because he let his papers get examined as soon as he died. And on the draft that was first circulated, written his hand across the top is, I really don't understand this case. Which, given what it did and everything, that's quite an admission, all things together. Justice Blackmun should be ashamed of himself anyway.
And the other, when we talk about Sanremo, the classic appellate litigant, when you're arguing an oral argument and appeal, is to not deal with the side issues or what ifs, what might happen, but all we're asking for is narrow relief to the Supreme Court or the ICA. And so, in the oral argument in Sanremo, Sandra Day O'Connor asked the landowner's attorney, "Are you asking us to overturn Williamson County?" And the guy said, "No, we don't need to overturn Williamson County or prevail." And Sandra Day O'Connor looked at him and said, "Well, maybe you should have." I was like, "Ooh." It's in the oral argument and transcript. Oh, that poor guy. I don't know who that is. Maybe we'll find out. Some practical thoughts, Greg.
Well, I don't have much to add. I mean, I think, any or most of us lawyers that do this kind of thing and handle takings cases or other property-related cases where there's a compensation aspect would certainly rather be in federal court than state court. And so this clears what was always a hurdle. I'd managed to get a couple cases into federal court because I guess if you represent a landowner who irritates a county enough, the county will sue them. And then if there's diversity, it gets into federal court on that basis. And then you can bring your counterclaim for a taking and due process violations and everything else. And so, but I think there are more on the way. I would have, I've got one on my computer screen that I haven't filed yet, so they're coming. But it'll be interesting. I think that recently, Judge, who handled Inalea, right? So Judge Mulway.
Mulway, I think.
So there have been a couple, takings and land use cases kind of going through the district court already. So I won't expand on that one anymore, but
okay.
Yeah.
The other, and it's not really a recent decision from any of the courts, but one, I think we'd be remiss if we didn't mention a lot of the vacation rental ordinance that was passed in Honolulu, as well as several enforcement initiatives on Maui and Kauai. And so there's been a lot of vacation rental discussion in the news and in the courts lately. Greg handled one of the challenges to the Honolulu ordinance, and because it's in litigation, I don't see Corp Counsel here, maybe you should give a little overview.
They're watching.
Okay.
Well, what we had on the list was HomeAway.com versus City of Santa Monica, which is a Ninth Circuit case. But that really scoops up a whole bunch of others. So what a lot of jurisdictions like Hawaii's counties are doing are trying to regulate illegal short-term rentals in areas not zoned for them. And around the country, the latest target, and obviously things have changed over 30 years, right, since Honolulu passed its first ordinance back in the late 1980s, in that you had the advent of the hosting platforms. And that's just like Uber and Lyft have changed taxis and that type of thing. Well, HomeAway, VRBO, Airbnb have changed kind of the marketplace in many ways. So many counties have targeted the hosting platforms as a way to try to regulate short-term rentals. And this year, the Ninth Circuit decided a question that a number of district courts had. And one of the ways a lot of jurisdictions did it, Honolulu didn't do this in Bill 89 recently, but a lot of them have said that a hosting platform has an obligation to monitor the advertisements that are posted on it and to confirm that the advertisement is for a legal land use. And the hosting platforms around the country have sued to stop those ordinances by saying the county's ability to regulate something like that is precluded by the Communications Decency Act, which is the law that kind of created a free internet, right? And the law that was intended to allow entities like Facebook and Twitter and Amazon and Yahoo and all these things to be exempt from liability for third-party postings on their site. And so the hosting platforms in many of these cases, and in the Santa Monica case, were arguing, you can't make us liable for an advertisement that somebody posts for a rental. And the Ninth Circuit in this one said that in fact regulating land use and regulating advertisements wasn't holding them liable for what was on their platforms, and so the CDA didn't provide immunity from these type of county regulations. But that's kind of only half of the issue, because elsewhere around the country, including in New York, Boston, Portland, you had district court opinions that came out the same way on the CDA, but at the same time, you had those jurisdictions they did something else. They said, oh, the hosting platforms on a monthly basis have to turn over a report to that city's version of Department of Planning and Permitting, listing all the people who are advertising, giving us their names, their addresses, the number of nights their unit was rented, the amount of rent they got for the unit, and their tax information, because that's not currently shared presently. And so it's this mass reporting requirement without any probable cause, any search warrant, any other government pre-approval of that administrative subpoena type request. And so those ordinances have been enjoined in those cities I mentioned. So even though the hosting platforms are losing on this immunity kind of argument under the Communications Decency Act, they are winning on Fourth Amendment or Secure Communications Act grounds where this compelled disclosure of information is required. Which brings us to what's now Ordinance 1918, which is Honolulu's recently passed Bill 89 that took effect in November. And one aspect of what that bill did was require this compelled disclosure by the hosting platforms, which would kick in October of 2020. And so we filed a suit in district court challenging the ordinance on a number of grounds, none of which would have ultimately thrown out regulating transient vacation rentals, because I think that's kind of established that it can be done, at least as a general matter. But rather it was there were a lot of problems with how they were going to do it and how DPP was saying it was going to enforce it. And one aspect of that was this hosting platform requirement. So we had a TRO hearing in August, and Judge Watson was assigned to the case, and he saw, based on the filings of us in the city, saw some common ground, kind of ordered us into some settlement discussions, and that's an ongoing process. But it's interesting that Honolulu, for better or for worse, is kind of on the forefront of some of these hosting platform cases that are around the country. None of the hosting platforms actually filed suit to challenge Ordinance 1918 yet, primarily because their obligations don't kick in until 2020. But that might be addressed if we're able to resolve some things. So it's a work in progress, but it's interesting. And the other counties are doing other interesting things with transient vacation rental. Maui, they issue permits for bed and breakfast and for short-term rental homes. And so there is a regulated process. And I guess depending on who you ask, it works well or it doesn't. But Maui hasn't even given out all the permits that are available under its process. It's very like Ordinance 1918 will kick in 2020 and give out about 1,700 bed and breakfast permits around the island of Oahu. So they're similar in that respect. And then Kauai is trying to shut down legal transient vacation rentals that they had to grandfather in when they passed their law in 2008. And that's been those are the cases that I referred to that are in federal court now and have been keeping us busy. But it's a hot topic, not just on Oahu, but everywhere in the state. That's all I have to say about Home Away versus Santa Monica.
Anyone have questions about TVRs? Because we're going to move on past that. Did you get your answer? Okay. There's a couple of cases which we think are going to the U.S. Supreme Court or Hawaii Supreme Court that aren't in our materials. Fowler versus Guerin, which is a Ninth Circuit decision recently, and that relates. It's a state employee retirement account case. However, it hits at the core fundamental aspect of Fifth Amendment as to the state's power to define what property actually is. Under the U.S. Supreme Court has always recognized that the states, and not the federal government nor the Fifth Amendment, has the power to define what property is. And that I expect to go to the U.S. Supreme Court because Washington's definition of property said that interest on a retirement account was not property, and interest classically has been recognized as property by the U.S. Supreme Court, and so that should be a good one to see how that turns out. That's the Fowler versus Guerin decision. Another one from Ninth Circuit, which came out just a couple months ago, is Cedar Point Nursery versus Sharoma, and that relates to whether state law, which requires landowners to open up access to their lands for people that are not invitees or employees. In this case, they were union organizers, excuse me. And in that case, the Ninth Circuit found that there wasn't a taking to have California require that union organizers be able to access this nursery for the purpose of organizing their workers. I think Pruneyard, which is a U.S. Supreme Court case, has come down a different way on that, so we might see more of that this year. The final interesting case is pending. The Ninth Circuit certified a question earlier this year to the Hawaii Supreme Court relating to the Ainalea project in Kona. And in that case, the issue that the Ninth Circuit was grappling with is, what's the statute of limitations for a regulatory taking or inverse condemnation claim in Hawaii? And which is kind of surprising that it can kind of come down on a couple of different ways on what that statute of limitation should be. Statutes of limitation are statutes which tell the world when you can bring whatever type of claim. The general statute of limitation in Hawaii is 6 years. The legislature decided several years ago that they want to shorten that time for certain cases like property damage or bodily injury, and those are 2 years. Claims against the state government have a different 2-year statute of limitation. And so there's never been a Hawaii Supreme Court decision that says, nor a law, which says what the statute of limitation should be for a regulatory taking inverse condemnation claim. And so the Ninth Circuit, when faced with that issue in Ainalea, said to the Hawaii Supreme Court, tell us what it is. There's a lot of briefing on the subject. Our partner Robert Thomas filed an amicus brief, and should it be 2 years like other money claims that you have against the state government? Should it be 6 years, the general statute of limitation? Or should it be 20 years? The adverse possession statute seems to be a kind of good theoretical proxy for this type of situation where you have the government through direct action regulation taking some aspect of your property, one of the bundles of sticks, and in Hawaii you could do that against your neighbor if you move your fence 5 feet over the line. If you hold that for 20 years and you're not on land court property, you have now adverse possessed that property and can claim title to it, taking therefore that 5-foot strip from your neighbor like a bundle of stick. And so there's a couple different constructs. I think it's excellent briefing in the Hawaii Supreme Court, and we would expect that decision out before the end of the year. So that's definitely one to watch. Okay, that's all on the off-script cases that we want to talk about. Now we'd like to turn to Hawaii Supreme Court cases, and there's a couple biggies that Greg and I will talk about, and then we'll go down to the Intermediate Court of Appeals, which we're not going to hit all the cases that are in our handout. Some of them are just 5, 6, 8-page decisions, but are included because they're a good synopsis of where at least the ICA thinks the law is. Okay, first up, TMT.
So TMT, I think we haven't had one of these sessions where we haven't talked about a telescope case. Between the various versions of TMT and the Kila cases coming out of Maui, it gives us something to talk about every year. So I'm sure you're all sick of it. Plus,
Yet they invited us back.
Plus you've all seen enough of it in the news. So that actually what I'm going to say isn't really news to anybody. So it's not surprisingly, well, I say not surprisingly. In 2015, when the Supreme Court reversed in the first Mauna Kea case, or the first TMT case, if you recall, we talked about that at the time, the land board voted to grant a CDUA permit for the 30-meter telescope before holding a contested case hearing, even though it had been requested. And You know, I kind of thought that was a no-brainer that was going to get reversed, and sure enough, it did. I mean, the court basically said you can't decide to issue a permit before you grant the parties who want to fight about the permit in a contested case an actual contested case hearing. So you had the remand. Judge Ricky Mayamano was appointed the hearings officer, and through a very lengthy process in 2016 and 2017, did probably, I would guess, the biggest contested case hearing that's occurred in this state, between the number of parties, the number of days of hearing, exhibits, and probably even, well, no, I wouldn't say that. Her recommendation, which then became the land board decision when she concluded the contested case hearing, was, I think, 200 to 300 pages. I was going to say that was one of the longest, maybe administrative decision and orders, but I actually forgot I worked on one that was also about 250 pages. So it was rather complete, as you can imagine, and as anybody would have guessed, it was appealed up to the Supreme Court. And that was a direct appeal after the legislature changed the law in 2016 by saying certain types of cases, including land board decisions on CDUA permits, you go directly to the Supreme Court, bypass the circuit court, bypass the ICA. So the opinion itself, I mean, we all know the result of it, right? They affirmed the land board decision to issue the CDUA permit to allow the telescope to be built. If they hadn't done that, there wouldn't be all the craziness going on the Big Island. I'm not going to really summarize much of the opinion for you, except that it covered anything you want to know about, like administrative law, about trying to disqualify a hearings officer or a deputy attorney general or land board members. That was dealt with in that opinion. It covered Native Hawaiian rights claims and how those, whether the land board in its decision respected Native Hawaiian rights with respect to what it was allowing up in the mountain. Dealt with that. That wasn't a grounds for reverse. Dealt with public trust and whether allowing a telescope on public land is a violation of public trust. Found that it was not. And then it also walked through the land board regulations requirements for issuing a CDUA permit and said that it fit all those. So at the end of the day, it was not a unanimous opinion. I think if I remember, it was 3-2.
3-1-1.
Yeah, there was some funky dissents and partial joinders. But anyway, that is the case, and so not a lot more to say about that. I mean, we obviously haven't seen the end of it in terms of, I don't know whether there'll be more litigation, but you know, whether construction moves forward is yet to be seen.
Thanks, Greg. There's another case that I want to talk about in the Supreme Court. It's the Tax Foundation of Hawaii versus State of Hawaii. A couple years back, in order to fund, to give the counties authority to add on to the GET to fund the rail, the legislature approved the 0.5% increase to the GET, but also said that, and GET reality, is scooped by, or is paid to the state tax office, and then they pay out the 0.5% to the counties, whoever has a surcharge. So we have a surcharge in Honolulu to help fund the rail, and so the state tax office collects the money and then pays out to the city and county in order to fund the rail. The statute also included a 10% of receipts to be allowed to be kept by the state tax office to fund that effort. And it kind of makes sense that if you're putting a work requirement upon the state tax office, that whoever's actually receiving the money pay for the load for that. Unfortunately, they use 10% and not some dollar amount. And so there is a lot of GET that's generated on this island. And over the past 3 years before it got challenged, that 10% was in the tens and 20s of millions of dollars, which eclipsed what the state tax office actually needed to administer the program. In this case, the Tax Foundation of Hawaii filed a challenge to that process and challenged that statute, saying that it can't be, it's not fair that the Honolulu residents are subsidizing the state tax office way beyond what they're actually getting the bang for the buck. It's kind of, if you go back to law school, taxpayer standing to challenge, standing as a taxpayer to complain about how my government spends the tax dollars that I give to it is a kind of a minefield or tough thing to get at. And so in this case, it was another fractured decision, and it's very hard to read because the justices agreed at different sections. And so you start reading the opinion, and it's 5 justices. Then the next section, only 3 of them wanted to do that, and then 2 dissented and whatever. Ultimately, the core was that they found that there was no standing to challenge it, and as a taxpayer, a couple of the justices would have allowed the standing to be under the declaratory judgment statute, but that's definitely one to watch. So the 10% will still keep going to the state tax office. Another interesting, last year we talked a lot about the 1978 Con Con as generating a lot of Supreme Court decisions. This year we see the 78 Con Con pop up in a couple of cases. The next one is Clare Ball, which is not a land use case, it's not a real estate case. It actually relates to, but I included it in the handout because it, I think, is emblematic of the Hawaii Supreme Court's carving out or gathering power unto itself to the derogation of the legislature and the executive branch when it comes to, under the veil or guise or justification of interpreting the Constitution. In Clare Ball, that case was the Con Con in '78 added a provision to our Constitution requiring that the department provide Hawaiian language at the state public schools. A Lanai resident in Clare Ball challenged that the mom wanted their child to go to an immersion school. And we've seen on Oahu, there's tons of charter schools that have Native Hawaiian immersion or Hawaiian language immersion programs. They didn't have one on Lanai. And so this mother tried to ask the DOE to provide one on Lanai. And Lanai said, look, we have, or the DOE said, we have Native Hawaiian classes in all our schools. We teach history. We have, hula, all the kind of cultural stuff. And so we can't provide an immersion for one student. Well, that went up to the Hawaii Supreme Court, and in a very lengthy opinion, they found, the Hawaii Supreme Court found a constitutional right to Native Hawaiian language or Hawaiian language immersion on Lanai. And so, you can come down both sides about the court telling the Department of Education how to teach or what to teach. However, when you look at the plain language of what the constitutional provision in '78, in the '78 Con Con said, it didn't use the words Hawaiian language immersion. And so from my perspective as a reader of the case, it looks like the Supreme Court, crowded out the legislature and the Department of Education and said, no, we're going to recognize a constitutional right. Now, constitutional rights, and we're going to talk about a couple other cases where the constitutional rights were recognized and then enforced, are very hard to, they're kind of more loosey-goosey. The statutory rights, we see it in the HRS book. You don't have to read a 150-page decision. Constitutional rights are a lot more amorphous. Right to free speech, what does that exactly mean? Right to assemble, what does that mean? How do you sort that out? You got to go through 25 U.S. Supreme Court cases to what is your right to be free from warrantless searches and seizures? And so we see now that the current Supreme Court is very, I would say, I'll call it aggressive in carving out that space, and it's very difficult. Certainly, I would say much more difficult at the federal level to amend the Constitution. But state, we do see constitutional amendments, usually one on each ballot. But I do think that Clare Ball is interesting, and yet another in a series of cases where the Supreme Court wants to make decisions about these things, like what the '78 Con Con actually means, and doesn't let the legislature define these rights by statute like other constitutional rights are done. Okay. Another '78 Con Con case.
Yeah. So the next one we want to talk about is Enry Help Co, Hawaii Supreme Court decision from this past year, which I think of really as MECO 2. So I think it was last year we were talking about the Maui Electric case that dealt with a power purchase agreement, and I mean, what the case is really about is who gets to participate at the Public Utility Commission when it's, you know, and I'm not a PUC lawyer, so they're not really permitting something there, but they're approving. And in the MECO case from 2017, late 2017, the Hawaii Supreme Court, or at least 3 of the 5 justices, recognized that the 1978 Con Con that said, I forget which provision it is, but says everybody in Hawaii has a right to a clean and healthful environment. The Supreme Court recognized that in the MECO decision that was a property interest or a property right that was entitled to due process protection. By equating that with due process protection, in MECO, just like in this new Help Co case out of the Big Island, they said that, okay, you only have a right to a contested case hearing or to participate in the proceeding before the agency if that is a hearing that's required by Constitution, by law, or by regulation. And usually it's by rule, regulation, ordinance, or statute that says when you get a contested case hearing. Well, the PUC's kind of statute is much different and doesn't give lots of people the right to a contested case hearing under Chapter 91. MECO found that it did, and Help Co in this new decision in 2019 says the same thing. And then it answers some other interesting administrative law questions, because the group that wanted to participate, it was Life of the Land. And if you read the decision, like all of us legal people, you always abbreviate the names. And I'm starting to laugh because the whole thing was LOL. LOL intervened. LOL did this. LOL, Life of the Land has been around, challenging bringing cases for 30 years. They may have to change their name because it means something different today. But they were given limited participation status to argue only on limited issues. And they did, and then the PUC didn't actually hold a hearing. It just approved the amended power purchase agreement. I would point out one other irony. It's only on the Big Island, and I apologize to those of you who are from the Big Island, but it's only probably on the Big Island that you would see an environmental group challenging a biomass fuel plant, which is what that was. They're burning green waste to create electricity, which to me, living here in Honolulu, I think that's pretty environmental, but it wasn't environmental enough. The problem was actually the PUC didn't really consider greenhouse gas emissions, which by statute they're supposed to, and that was the argument that LOL wanted to make. And so the Supreme Court also said, well, they didn't have to actually have a hearing to have the right to appeal pursuant to Chapter 91, even though the statute says that the only people that can appeal an agency decision are those that participated in a contested case hearing. So it talks about this due process right. I think that the net result, and Mark and I were talking about this, is really, and you see it it's a common theme in some of these other cases we'll talk about, and I find it's more with the state and state agencies than maybe the counties, but they seem to not like contested case hearings. And I get why after reading the TMT decision and knowing what went into that contested case hearing. But the PUC and the Department of Land and Natural Resources, or the Land Board, tends to deny people contested case hearings. And then the practical result of all that is you go through a very complicated process, particularly at the PUC and all the things they consider in terms of the rate making and business and all that other stuff, only to tell somebody you can't participate in this, even though you want to and you've got an interest you claim you want to advocate for, and then you waste years and you go up on appeal, and the Supreme Court says, well, you cut them out and they had a right to be there. So that's kind of the ultimate lesson there. And I suppose for practitioners, it would probably be you're better off letting that person come in and dealing with their arguments, on the merits, and having that reflected in the decision and prevailing on the merits, than keeping them out of it and having them have the right to appeal, because they will under Chapter 91, and circuit court might not do it, but the appellate courts or certainly the Supreme Court will send it back down, and that just takes years. So it's better to some extent, better let people participate.
Yeah, this one is a hard one too. You know, when you have contested cases at the LUC or the land board, usually the issues are a little more less sensitive confidentiality-wise, but public utilities are private companies that are given a monopoly to operate, and they're allowed to, by statute, by rule, allowed to make profit. And so now you have the potential that interveners can come into PUC proceedings, and if you're a party, you're a party. I think that the one saving grace of the Helco case was that the Supreme Court was okay with the LOL, life of the land, being limited participants, which I think would allow the utility and consumer advocate to cabin off some of the sensitive financial information from review. This is an interesting case too, because by statute, the legislature told the PUC a couple years ago that they had to consider greenhouse gas emissions, and I don't know why it wasn't. It's a rate case or a PPA, just on usually negotiating. Okay, I'll buy electricity from you, producer, at 20 cents a kilowatt, whatever. And is this a fair deal? Is it achieve the goal to diversify and shift away? So it's kind of an unusual context. Although MECO was an unusual. That was a PPA as well. So anyway.
Next one would be City and County of Honolulu versus State of Hawaii.
Well, that's good.
That's a very generic title that might not mean anything to you, but this is the case about the ballot question, about allowing the one that was pushed by the Department of Education to allow basically a surcharge or a tax to be placed on certain investment real property. And I guess because the subject is real property, that's why we're talking about it. We're not talking about election law and whether a proposed constitutional amendment is vague and ambiguous. So since we're not doing elections, if you like elections or you like, want to know what a vague and ambiguous question is, go ahead and read that decision. The decision is also healthy because interesting for us today because it tracks the evolution of real property tax taxation authority in the state of Hawaii. It had been at statehood a state power. At some point, with a lot of fighting by the counties, as we all know now, it devolved to a county power, and their sole source of revenue, other than what they get through TAT or GET, and their small cut of those things. So this case was a lesson that the counties fight vigorously to protect that right to receive real property tax income, as all 4 counties joined in and fought that case. And so it's just also, I think, interesting because it was, the 4 counties fighting with the state. But as we all know, the Supreme Court struck that ballot question from being on the ballot, saying it was too confusing and too many of the terms were undefined, and us voters wouldn't have understood what we were voting for.
Yeah, there was the Civic Con Con. It's kind of a theme the last couple of years, but that's what transferred exclusive authority over property tax to the counties. And it took 10, 15 years in order to devolve that tax administration, the assessment, the appeals from the state tax office out to the counties. And so this was another interesting time where the 78 Con Con came back again to the Hawaii Supreme Court. There was the oral argument. It was one of those awkward moments, but the elections and the need to print ballots tend to drive a lot of anxious times, and so there isn't a whole lot of time for full briefing. I think from lawsuit filing to Hawaii Supreme Court oral argument was like a month or two. It was really quick, but Justice Nakayama had a lot of questions about the wording of the question, and I think one of the attorneys actually said, well, maybe you just shouldn't vote for it. And yeah, I'm not sure I would have said that to her, but anyway, the fourth 100+ page decision out of the Hawaii Supreme Court we're going to talk about is Ching versus Case. This is relates to the Pakaloa training area that on the on Hawaii Island. The state of Hawaii, and the leased area that we're talking about in this case is not the whole training area. It's kind of a mix and match up there where the feds own some, and some of it is leased by the state to the feds. I think there's about 10, 15 more years on that lease, and it's 22,000 acres. But a resident challenged and brought a claim against the landlord. So technically the state of Hawaii is a landlord, the federal government, the United States Army, is the tenant, and they have a lease. It's pretty short. It calls for the payment of $1 a year in rent for 22,000 acres, and the Army uses it for combat training with tanks and bullets and mortars and the like. And a resident challenged the state's stewardship as being a landlord to ensure that when the state gets the land back from its tenant, the federal government, that no environmental harms are brought with that. And it's kind of an interesting concept where in any contract, whether it's a lease or whatever, usually the only two parties that get to talk about the terms of that contract are the landlord and tenant, or the contracting parties. And in this case, the Hawaii Supreme Court recognized that the state of Hawaii, as trustee of these public trust resources, could be held to account and answer for breaches of fiduciary duty as trustee of those lands, even if there was no underlying breach of the lease contract. And so it's a very dense decision. The challenge was actually brought here. Judge Gary Chang in Circuit Court issued about 10 different specific remedies, mitigation plans and monitoring efforts, whatnot. And the Hawaii Supreme Court actually went line by line through them and said, yes, we agree that that should be part of the trustee/landlord's obligation. This one shouldn't, remand this. And they kind of went line by line. It's a very dense read. I think the procedural history is like 40 pages in of itself. And so you can flip through that just to get to the discussion. But the other kind of interesting aspect, so public trust has been part of the English common law in a very narrow sense, usually dealing with submerged lands or lands that are underwater, stream, tide lands and the like. Of late, the public trust doctrine has expanded in the state of Hawaii through a couple of decisions, most prominently the Kauai Springs case from 5, 6, 7 years ago, where the Hawaii Supreme Court recognized in another 150-page decision an extensive public trust obligation on behalf of every governmental entity to enforce and uphold it. Now we see that, and so public trustees, it's not like the trustee of the Bishop Estate or the trustee of the Mark Murakami Revocable Trust. And so what's interesting in this case is the Hawaii Supreme Court actually cited to the Restatement of Trust and treated the state as more of a fiduciary type trustee instead of the paternal state government type trust relationship. And so more to be seen. I think it just opens the door for more people to challenge state governmental action, and it's another aspect of real estate that we have to contend with. Yes, sir.
We should add one thing here. Watch the public trust doctrine and public trust cases carefully, because our Supreme Court, like a bunch of other courts around the country, confuse the notion that government can't hold land as really a private landowner. It holds for the people, and therefore it's holding it in trust for everybody. And the public trust doctrine, capital P, capital D, capital T, capital D. It's an important distinction that other courts are starting to make. And the way it could start coming down, if you read the concurring and dissenting opinion of Justice Pollock in the second TMT case, you'll find that he takes the Supreme Court majority, 3-justice majority, to task for creating 2 public trust doctrines, one for land and one for water. And that may in fact be true if in fact what the court did is establish the public trust doctrine did apply to a mountaintop, which is the furthest any state anywhere in the country has ever established that the public trust doctrine applies. Now, it's not just picking nits because it was Justice McKenna that wrote that opinion, if I remember correctly, and she studiously avoided, in 99% of her opinion, using the term public trust doctrine, just public trust. So there may be a real set of issues here on distinguishing the PTD, which, as Mark suggests, has a long history all the way back from an 1890s U.S. Supreme Court case from Illinois, and the fact that government always holds land for its citizens in some sort of public trust. And if you're interested, of course, I tried to write something about that, and it'll be out next month. If you want a citation to it, just send me an email. I don't expect I'm going to get a lot of adherence, but I start my exposition on the public trust doctrine with the notion that the two are distinctly different and they have to be treated differently.
Me next.
Oh, yeah.
Okay, tired of talking about the government, let's talk about private people suing each other. The next on the list, and the last one of the Hawaii Supreme Court decisions we're going to talk about today is Calipjo versus Purdy. And that's a case that came out of Kauai, and it was a DROA case, so it's just sale of property. It was actually a sale of 2 condominium lots, and what was interesting, I think, in the case is that the seller and the buyer negotiated, and the buyer had an option to purchase the second lot if he went through with the first lot. That was written into the DROA. The seller, who I think created the DROA, and his realtor read over the DROA and said, well, wait a minute, if he's got an option to purchase the other property, I should have an option. Why should he have the only option? I should have an option to cancel this deal if I want to, without any notice to him. So they wrote that into the contract as an amendment, and the buyer met with the realtor, who explained it and said, oh, that's just boilerplate, that's okay. So he signed off on the on the addendum, and it became part of the contract. And then the evidence that went before the jury was that, well, I should say, the evidence was that the seller never really intended to sell to this guy, and he was just soliciting these contracts to then be able to go out and shop it to get financing and to sell them for more to other people. That was the evidence. So anyway, as you can guess, the seller exercised at some point his unilateral right to cancel both contracts, and then he got sued. And he got sued for breach of contract, for breach of good faith and fair dealing, or unfair and deceptive trade practices, I should say. And then the other aspect of the case dealt with, they claimed that the seller was, as anybody who's smart, and I'm sure you all counsel your clients, it's like, don't hold the property in your own name, hold it in an LLC or a company, which is what they did. And there was evidence that these properties were being transferred between the companies, and the company was undercapitalized. That was the party to the DROA. So the purchaser sued the owner as well, claiming alter ego, so that there'd at least be a pocket to go after. Jury verdict in favor of the buyer and against the seller on all these grounds: breach of contract, unfair and deceptive trade practice, and alter ego liability. So the individual seller was personally liable as well. ICA reversed that. Then it went up to the Supreme Court, and they affirmed the jury verdict, and they found there was sufficient evidence. Beyond that, it's not that interesting. They found there was sufficient evidence to support all those claims, including the alter ego, which is, I guess, the only one that most of us lawyers are always scared about, because, the corporate fiction is just a corporate fiction, and they can always get after somebody and make it more difficult. But, you all familiar with the Roberts versus Lapahoihoi Tours 25 factors of what's alter ego. This one, they talked about only 3 of them that found that it existed, and so they allowed the piercing of the holding company shell.
What's the citation for that case?
I've got it's April. I don't know if I don't have the Hawaii Supreme Court opinion. I've got the but it's spelled Calipjo.
It's the handout that got emailed. It's a hyperlink, so if you click on it, you'll get the original opinion.
Yeah. It's not to the Hawaii Reporter, but straight from the Supreme Court website.
Okay.
Oh, I should mention one. We mentioned one case to look for from the Supreme Court in the coming months that Mark mentioned will be the taking statute of limitation case in the referred certified question from the Ninth Circuit and the Inalea case. Another one that I just argued at the Supreme Court in the spring, and I thought we'd get a decision, is another development case dealing with a lawsuit down in Waikiki over condo hotels and DPP permitting processes. I don't know what the result will be, but if depending on where they go with it, it could cover things like permits and changing of permits, public notice, public participation, maybe dealing with condo hotels, but probably not. So that's another opinion that'll be coming out soon.
Okay, now let's turn to the ICA. We have 30 minutes, so. Okay.
We can cover these quickly.
Yeah, go for it.
In fact, I'll cover them so quickly I won't say much about them. The one on the list is Kokua Council versus Department of Health, and that was really a Public Information Act case. And the only thing that really matters, I think, for land use lawyers in particular, or litigators, is it's all about mandamus, and when a circuit court judge can order a public official to do something or not, and when the Supreme Court has the power to issue that. The actual holding was that a circuit court has no power to issue an order of mandamus ordering the director of the Department of Health to post, adult residential care home inspection reports on the internet, where the state was supposed to be posting them. The relief was sought at the circuit court, and the ICA said that the circuit court, under the statutes and the rules, and it's all discussed in that opinion if you want it, circuit court doesn't have that power, only the Supreme Court does, to order a public official to do something as opposed to an individual. And so this case teaches us that public officials are not individuals, at least for mandamus purposes. Next one is Keauhou Canoe Club versus DLNR. And this was those two are both memorandum opinions, so for what that's worth. But DLNR was going to add moorings in Keauhou Bay for boats. They came out with the announcement that they were going to do that, and the Keauhou Canoe Club said, well, don't you need to do an environmental impact statement first? They were told by DLNR, no, we don't, we're exempt. Plaintiffs, or the Canoe Club, sued to require them to do an EA or EIS under Chapter 343, filed a bunch of motions, and as the motions were pending at the circuit court on whether an environmental impact statement was required, they essentially settled by signing stipulation with the state agreeing that it would not build new moorings without doing an EIS first. And then the only reason, so the case settled, right? Yeah, no, because on the appeal, the one claim or the one issue that wasn't resolved was whether the Keauhou Canoe Club gets attorney's fees and costs against the state of Hawaii under the private attorney general doctrine. Circuit court held that they did. And one of the requirements on the private attorney general doctrine is that you have to be the prevailing party, when there seemed to be a settlement. The ICA looked at it and said it met all the requirements for private attorney general, including that they got the result they wanted through the lawsuit, even though it was kind of settled without a ruling from the court. So they were entitled to attorney's fees as private attorney generals. They were also entitled to costs, and this is against the state, but they weren't entitled to prejudgment interest on those fees and costs because the state didn't waive its sovereign immunity.
Cool. So, and I went to law school in 96 to 99, and so one of the classic Hawaii cases that makes it into the national law school textbooks is the case of Weitzel versus Houghton. And it was a decision of the ICA's second year, so it came from 1982, authored by Chief Judge Jim Burns, and I actually had a chance I was sitting by him about a year before he passed away, and I mentioned to him that, Weitzel, I was out gardening in my yard a couple years back, and there was a bananas hanging over my wall from my neighbor's property. So I took a picture and said, oh, this is a good time to educate the public on Weitzel. And so I did a big blog post about, what the law allows vis-a-vis those bananas. And then I actually ended by saying, but I lose my neighbor if I take the bananas, and so I should just let it be and move on. Anyway, so I had a chance to talk to Judge Burns at the law school about a year before he passed away, and I told him, I was like, oh, this is the most famous case from Hawaii. It's all, and he was really surprised that at the longevity and the whole, I think it's Whitesell's about an 8-page decision, and it's who owns what with a tree that's on the property line, and who has what duties, what can, if your tree comes onto my side, what can I do? Can I carve it down? Can I get an injunction against you to cut it down? And it's so simple, and I think it's kind of a model of the common law of a court, seeing a situation, looking at what the legal rules are out there, applying it, and adopting law. So I was pretty excited in the Spittler versus Charbonneau, excuse me if I pronounced that wrong, case, where the ICA revisited Whitesell this year, and it's another one from the Big Island. And so what was left, the holding of Whitesell was that for non-noxious trees, the landowner could obviously cut anything and remove roots or fruit. Everything on the property line on his side or her side was theirs. But for non-noxious trees, they weren't going to find that it's a nuisance, which would enable, if the court recognized that it was a nuisance to have a tree so close to the property line or something dropping on my side, you can get an injunction for nuisances. And the court wasn't willing to recognize that for non-noxious trees. They didn't define non-noxious trees, and so Spittler comes out, and the court attempted to define what the ICA meant when it said in 82 for non-noxious trees. And you'd be surprised at what, it's not a defined term. The noxious, the litigation was about, there's a noxious weed website that the state has on it. I think it's the Ag Department website. And so the question was whether an ironwood tree, which was on the property line between these two property owners, was a noxious tree or noxious weed. So they went to Black's Law Dictionary and trying to define what noxious tree is. And ironwood, that's Kailo Beach and Waimanalo, they're everywhere, but it's on one of the, because it has pine cones and for some reason it's on some native noxious weed website. And so these two neighbors, and it's a very colorful decision. There were actually shots fired between the neighbors. Let's just say it was a very complicated neighborhood board situation. But I encourage everybody to take a look at that. The ICA actually clarified Whitesell and did recognize that unless there is a imminent risk, actual harm, so tree branch falls on my child in the backyard, or the tree branch falls and it smushes my fence. If it's actual harm, then the ICA recognized you can get an injunction against your neighbor to cut it down. You've always been able to cut, I could cut down myself, but if you're talking about, 80-foot tall albizia tree or something, that might not be something that the weekend gardener really wants to undertake. And so the ICA did recognize that if there is risk of harm, they will recognize that there is a nuisance, which gives rise to the injunctive relief. Anyway, that's a good one.
Is the risk of harm just physical harm? Because what if you get a tree?
I think it says injury or property damage. Okay. So now the tree root coming on my side, busting up the wall, I've always been able to cut that on my side of the land. Now it's a very short decision. Judge Hirooka wrote it, but I think that if it's an albizia type situation where it'll kill somebody, I do think they would recognize the power to get an injunction to go on to to force the other neighbor to cut back his tree if you didn't want to wait for it. But it's a pretty high standard, and I don't know how the economics of these types of cases work out. A standard appeal will probably cost $30,000 to $50,000 to do, and I guess if my neighbor was shooting at me, I might not want to go cut it down myself. But, anyway.
And you cheat on an appeal.
Okay. There were two companion cases, the Bruno versus Aoyo of Waikiki Marina Condo and Crow, which were both, it was a Savio conversion, and when you convert an apartment building to condo, you have to get parking, and so the Waikiki Marina didn't have any parking, And so they made a deal with a neighbor to lease them parking. And so in the declaration for the Waikiki Marina, it recognized that the owners of condo units there had the right to access a common element pathway to get their cars. And so the question is, well, if these owners have rights to this common element pathway to get my car, do they have rights to all the common elements of the next door neighbor, the pool, laundry room, whatever? And the ICA in 2 unpublished decisions found that they did. So note to drafters or anyone looking at Savio CCNRs that they might want to look at that hard or draft around that. Okay, Sandomeyer.
So speaking of drafting, Sandomeyer, and speaking of neighbors versus neighbors, Sandomeyer versus Brown is, you all remember our classic case of Sanremo versus Larson. It is to restrictive covenants in private developments what Weitzel was to trees and branches, right? Sanremo v. Larson was a Hawaii Supreme Court case from, I can't remember, the 80s probably, where the restrictive covenants in the neighborhood said you can't go above 2 stories. It said more than that or better than that. Neighbors saw their neighbors building a 3rd story, sued, got an injunction, mandatory tear down order, right? And that's the Supreme Court said that based on the language of the CCNRs that were recorded for that subdivision. Then all lawyers who kind of practice in this area, we have a whole bunch of cases since then that have really watered that down under the theory that restrictive covenants and other restrictions on the free use of property need to be narrowly construed. So if there's any ambiguity, they're not going to be enforced. And so you had cases like Heiner versus Hoffman, and what was the other one? Pacific Palisades, where restrictive covenants that seem to prevent people from putting a 2nd story on their unit or doing other things found those to be ambiguous because 2nd story or a story is undefined, right? And so people were allowed to go ahead and build those. And so you had this kind of weakening of the Sanremo versus Larson theory. Well, now we have Sandomeyer, and keep in mind this is the Intermediate Court of Appeals and not the Supreme Court. It comes out of Wailaiki 4 subdivision, and there they had neighbor saw other neighbor, downslope neighbor, beginning to do some renovations, looked at the CCNRs, and their CCNRs, the suit had to deal with 2 things, height and building area. The height is what's the interesting things, that's all I'll talk about. And they had 2 different height restrictions on those lots, and obviously the intent being to preserve, it doesn't say to preserve views, and they don't guarantee views, but when you have a height restriction, that's the purpose. And so there were 2 different height restrictions that could be calculated, and based on, they went to a preliminary and then a mandatory injunction hearing, essentially a trial, and both the plaintiff, the neighbor, and the defendant, the homeowner, called their various architects and experts to talk about what these restrictive covenants meant and how they were going to be calculated and applied to the property. And the plaintiff's experts testified, so the restrictive covenant that was really the subject of the case said no portion of a structure or building shall be greater than 18 feet from the highest corner or portion of the building site, except for they could have antennas and chimneys. So 18 feet. And then there was another one that applied to different types of structures, but that wasn't really an issue in the case. So this 18-foot one, all the experts, or the battle of the experts was whether that was like a straight line on a sloping property or whether it was a plane that decreased. And the plaintiff's experts who prevailed at the trial court said, well, it's a sloping line. It's not a flat 18 feet, but it follows as the grade goes down, so does the 18-foot restriction. And the defendant's house was going to intrude above that at some point. And so the circuit court agreed, said you can't build that high, issued the permanent injunction, the appeal went up. And what the appellate court said was interesting. It said that you don't rely on testimony, you don't interpret restrictive covenants, you don't determine what's reasonable or not if it's plain and unambiguous. And they said this one was plain and unambiguous. And they even wrote the word period, like plain and unambiguous, period. So you don't get any further because so what they said was 18 feet means a straight line at 18 feet. It doesn't mean if it didn't say that it descends as the grade descends, then it's just 18 feet from the highest point. So they reversed and remanded on that basis. So it's interesting. The ICA is maybe we're coming back to Sandstrom a little bit more than Heiner versus Hoffman, but the very difference of, and obviously it's true, talking about specific feet, that's not vague and ambiguous under Heiner versus Hoffman. Second story or 1.5 stories, that's vague and ambiguous. So you do want to be specific, and if you mean to have a descending line that follows the grade on a sloping property, you should say that in your declaration.
Yeah, I think the ICA in that case really took the circuit court to task because the circuit court said, well, is this ambiguous or what's the most reasonable interpretation of this? And the ICA very plainly said, if it's not ambiguous, then whatever interpretation is those words. And this says 18 feet at the highest point of elevation. That's what you apply. You don't introduce a reasonableness concept to it. And so, very fascinating. We're kind of getting compressed. I want to skip ahead. Thank you, sir. There's a case in the oral argument was at the Supreme Court yesterday, and I attended. It's the Malabé versus AOAO Executive Center. And what it turns on is it has to do with the condo association's non-judicial foreclosure powers. And during the downturn, you have condo associations getting unpaid homeowners assessments, and so usually compared to the mortgage amounts, they're chump change, $5,000, $10,000. And so the condo associations after the downturn did non-judicial foreclosures and did that process, took the condo from the person subject to the first mortgage or the mortgage, and that caused a lot of drama. There was mortgage foreclosure task forces and whatnot, but ultimately then what happened was the ICA case in Sakal, I think it's versus AOAO of Hawaiian Monarch a couple years back, recognized that condo associations don't have powers of sale, and the statutory provision they were exercising the non-judicial foreclosures under is entitled power of sale. Power of sale is a term that's in every mortgage that you've ever seen, and it gives the mortgagee or lender the power to take your property non-judicially. The issue is that association condo docs have to explicitly say that, and in the Sakal case, they don't. It didn't. And so trial judge here and then the appellate court recognized that there's a valid claim for wrongful foreclosure if your association did a non-judicial foreclosure on you and you lost your property therefrom. And the damages the associations are facing could be huge. So there's a couple class actions that started against the law firms that did them, and I think there's a couple that are pending in federal court for trial. Anyway, flash forward to Malabé versus Executive Center, and that's a non-judicial foreclosure conducted right across the street here. The owner found out about Sakal and then brought a claim after they had lost the property. And but then, so while this claim was pending in circuit court and even up on appeal, the legislature, and let me take a step back. So the non-judicial foreclosure enforcement regime is set forth in Chapter 667 of HRS, which is in the civil remedies type section of the code. Now condos are governed by 514, 514A, and now 514B, which 514B is probably 6, 7, 8 years old. And in 514A and B, it recognized that condo associations have the powers to do these collections of assessments and whatnot. So the issue was to what, and then this year, as a result of all these lawsuits going against the AOAOs, the ledge amended 514B, or said, hey, look, we have always intended that condo associations have the power to non-judicially foreclose as legislative history. The problem is that the original legislative history for the statutory provisions that they're talking about in 514B, 514A, didn't have any of that stuff. And so here we have the current legislature changing the legislative history about a statute that was passed 10, 15 years ago to the detriment of these people that are currently in court and have won in the ICA. And so the ledge passed earlier this year, Act 282, the governor let it become law without signature. And so the issue is, well, how does that impact all these people that were wrongfully foreclosed? And what power does the legislature have to recognize this right? And the startling thing about the oral argument was, they're going back and forth about the 667 statutes versus 514B statutes and whatnot. But ultimately, if you take it back to Property 1 class, this is really on how the legislature and the courts should view property. And whether it's the Locke view, the bundle of sticks approach, that you and I sign a contract, I'll let you build your wall on my land, I've given you or sold you one of my sticks. Between us, that's this contract theory. The other kind of theory in property is Thomas Hobbes, another old English philosopher, who thinks that property, the concept of property, is a governmental and or society recognition of rights. And that the government doesn't give you, it recognizes your right to property. It's not like you have that as a bundle of stick, it's the government just recognizes this list of property rights. And if the government doesn't recognize it, whether that's a regulatory taking or whatever, then you don't have it. Sorry, you lose. And so what's fascinating to me is the CC&Rs, from my perspective, are the contract between homeowner and moving into the condo association. And so from a Locke theory, it shouldn't really matter if that covenant or that contract between the two people doesn't have a power of sale in it, where you can do the non-judicial foreclosure, then from my perspective, the association doesn't have that right vis-a-vis me. But the association's view is that, no, this has been, implicit in the condo statutes early on, and that everybody has notice of HRS. It's lawfully, validly adopted, signed into law, published in the books, and it is just part of the property right that we will recognize was given up by condo owners to have their property lost to non-judicial foreclosure. It was a very, the association attorney had a tough time with the Supreme Court. They were very, I think several of the justices were troubled. What's weird is they didn't mention CC&R once, but because I'm a Locke guy, but they did. I expect them to, the Supreme Court, to find that the associations didn't have this power to non-judicially foreclose, and therefore the landowners do have a valid claim for wrongful foreclosure. That's hundreds and thousands of dollars. The equity it lost might be a measure of damages, and the law firms that were involved in the foreclosures, I expect, I think because the ledge changed the law now for new condo projects or condo projects that explicitly reference 514B as amended, I think those going forward, I think it's going to be clearer what AOLs can do vis-a-vis unpaid assessments. But for that gap group of folks lost during the downturn, I do think that the associations and these folks are going to have a lot of litigation in the future, because I think the Supreme Court's going to come down and say Act 282, this is just Mark, what do I know, but Act 282 is prospective only, and they're going to reject the retrospective application. Anyway, we have like 6 minutes left. Do we have questions? Oh yeah, I'm sorry. Is this mine or yours? Oh yeah, I gotta do Dow.
Yeah, okay, so let me talk about Dow, because I just love transient vacation rental things so much. This is a published ICA opinion, and it's interesting, and it relates to transient vacation rental, or enforcement, but it really relates to a lot of things, DPP or other county planning department enforcement questions. And so if you fight with the DPP or other planning departments, or you go to the Zoning Board of Appeals, this has some relevance. But what the case was about, a house up on the North Shore, which was allegedly being illegally transient vacation rental. people turning in and out multiple times within a given month. So the DPP gets a phone call from somebody that the DPP won't identify that says, hey, I think there's a transit rental at such and such address. Inspector goes out, meets a guy standing there. He says, are you renting this property? The guy says, yes. He says, is the owner here? The guy says, no. I think he said, how long are you here for? And he said, what's your name? The guy said, I'm not going to tell you. Or at least that was what the evidence was. So it was an unidentified person who basically admitted that there might be a transit vacation rental there. They issue the notice of violation. That's violation number 1. And then a few weeks later, there was another complaint from a neighbor. Inspector went back out to the house, talked to neighbors, and 2 different sets of neighbors who identified themselves as neighbors had kept logs of rental vehicles coming and going. I think they said, 20-something cars over an 8-week period. People would stay for a couple of days and then leave, unloading and loading luggage. They were actually keeping written logs, which DPP had suggested they do. And there was some other evidence, so they issued a second notice of violation. And so Dr. Dow, he was a doctor, appealed both of these to the Zoning Board of Appeals, which, as they tend to do, affirmed. Basically said, well, Dow wanted to complain about all this stuff and say, I wasn't really renting and that wasn't illegal. And they said you didn't carry your burden to show that DPP erred. So he appeals to the circuit court, and then it makes its way up to the ICA. And it's interesting, and I think it's relevant for these kind of points. The ICA looked at that first notice of violation that was based basically on an anonymous statement of one person, of somebody that neither the DPP inspector could identify, certainly Dow couldn't identify him and cross-examine him or anything else. And the ICA said that issuing a violation based on that evidence and nothing more was not an agency decision based on reliable, probative, and substantial evidence that a violation occurred. So they said that was improper to issue. The ZBA was wrong to affirm that. And they went through a list of some of the things that the DPP should have gotten that would have supported a violation. They said, for instance, other than this anonymous complaint and an unnamed male stating that it was a rental, they had no personal observations of the inspector. There were no neighbors were interviewed. No other investigation was done to corroborate the statement. It's kind of like the Steele dossier. It was completely uncorroborated. Sorry, I had to bring current politics into it. I talked about the protesters on the mountain. Now I'm talking about DC.
You have to go there, dude.
No monetary transaction evidence or anything like that. And so, so they said that was an improper violation. Then they looked at the second violation, which, as I described, had a lot more evidence. The inspector went out after there was a complaint. He talked to 2 different neighbors who kept lists of cars, neighbors who said, I saw 20-something cars come in and out over the last 2 months. Then they got some rental contracts from the guy, which looked like they were backdated and created after the fact, and they were for overlapping periods of time. If he was doing it correctly, he could have only had one 30-day rental, one person in there in a 30-day period of time. And so the ICA said that there was reliable, probative, and substantial evidence to support that second violation. Although the DPP treated that as a continuing or a recurring violation and imposed higher fines because it was the second time, they said, well, it wasn't the second time because we threw out the first violation. And then they concluded with saying the fines itself is interesting. So how DPP does this is if they issue you fines and you don't correct that violation, they treat it as every day as another $1,000. Under Bill 89, it'll be $10,000. But every day is $1,000, and they'll send you a letter, maybe a year later, and say, you never corrected that. Your fine's now $365,000. And the ICA, that's how they treated this one in Dow too. They said, well, there was this whole long period of time before you finally corrected this by showing us that the unit was vacant and showing us it wasn't being illegally rented. So we want I don't know what it was in his case, $60,000 or something. The ICA said, no, city, you need to prove that every day that you want to fine him, that there was an actual rental going on. You can't just let this fine run, because it's your burden of proof to show that the fine was in fact incurred for an illegal rental on a particular day. So that's interesting because it changes what DPP will do, and the other counties kind of operate similarly.
Okay, we have 1 minute left. I'm gonna pull the hook, dude, sorry.
Yeah.
If you advise commercial landlords, you need to look at, it's an ICA memo op, but it's Hawaii Ola'a versus Hawaiian Sun Investments. There's a self-help case where the landlord self-help evicted its tenant for breaches of the lease, but it wasn't related to payment of rent. And the ICA recognized a wrongful eviction claim in that situation. So it's spooky. It's a short case, and I don't think the ICA meant to say what I think it says, but before you advise your landlord clients to do a self-help eviction, you want to make sure that they actually have a material breach of the lease. Anyway, that's it's linked there, Hawaiian Sun Investments.
I want to thank our panelists today for a superb holding forth for 9 minutes. As I said before, they're all
from the chair next year. We have another meeting in this room, so I want to ask if you could please take your questions for the speakers outside. And I'm going to send an announcement about this, but Professor Callies was nice enough to bring these little flyers about this wonderful lecture coming up at the law school in November about homeowners associations.
That's good.
Yeah.
Thank you.
Thank you.